This is a video made to explain the will. We will talk about how to write the will and also some general information that might be useful to understand in this subject. There are lots of will writing templates that you can find online. There are also many places that can provide a will writing service for a fee. With so many variations, it's easy to become confused with what is correct. There's also a risk that what is written can be misinterpreted, or more commonly, people might dispute with what you wrote down. Historically, will writing can be a contentious subject. A simple Google search can immediately show examples of contentious will cases. This is a random search I did while editing this video. As you can immediately see, the legal costs that come with disputes over estates of dead relatives or family members can be incredibly costly. And it's all the more frightening when you imagine your family being torn apart by disputing claims. So in this video, we'll try to do more than just explain the proper procedures. We'll also try to get a deeper understanding of why things are done a certain way, and we'll try to define the terminology as we go along. So how do we start? Well, you can always use a pen and a paper, but you have to make sure that the writing is clear and legible. Otherwise, you should consider typing and printing the will. Remember that this document will have to be shown in court at some point, so it's nice to make as much effort in making your will presentable. You should also try to make multiple copies of your will in case one should get destroyed or lost. Typing your will in a Word document makes this easier and also allows you to keep soft digital copies as well. So what do I mean by making extra copies of your will? This doesn't just mean using the printing machine to make copies, but rather signing 3 identical copies of your will to create more than one original signed copy of the exact same will. On the day that you sign these 3 wills, you will produce 3 identical copies which can now be handed to people you trust. In the event that one or more original copies are lost, the other copies can be produced by the people who hold it. As you can probably guess, being able to produce the correct will can be very critical and can be incredibly decisive for the future of your beneficiaries. So now we can talk about the process of writing the actual will. So the first thing you want to write down is your name. You can also include some sort of identification like an identity card number. You can also include your address at the top. The most important thing is your name, but adding additional information I mentioned above is standard practice for professionally written wills. If anything, it will add to the seriousness of the document you're writing, so it's recommended that you include it. It's also common practice to capitalize all names and information. Additionally, you should make a statement that you're writing your will, so no one can dispute your intention and the purpose of this document. Explicitly write out in the introduction that this is your will. You can pause the video and follow my example here. After the introduction, we will briefly talk about the revocation clause. If this is the first time you're writing your will, then you can ignore this step. But it would be good to understand the concept behind this clause. Writing down the revocation clause will revoke any previous wills, so the one you're writing becomes your final will. If you have written more than one will in the past, then this will help avoid any disputes about which will is the right will. In the past, people have tried to disprove a will by claiming that there's another, newer will written by the deceased. This is why it's important to disclaim every other draft of your will, and to ensure that every wish you have is written down in one final declaration. This also means that you should never forget to write the date down when you have signed your will, so that everyone else knows whether or not this is the most recent will that you have written down. Again, this is a step that you should worry about only when you have written a will in the past. Next, appoint your executor. This is the person that will represent you. The court will appoint the executor which you have chosen in your will. They will have to manage all of your assets and liabilities. So for example, your house and your mortgage. This is a position of great responsibility, as the executor can be answerable to the court and beneficiaries if they fail to carry out their duties. They are also in a position of power, which means that they can abuse the power given to them. So it's probably good to appoint someone you know that is capable of managing this responsibility. It's also crucial that you appoint someone you trust. So when writing this down, you simply write, I appoint so-and-so to be my executor. And you should follow the rules from before. Include the full name, identification, and their address, and make sure everything is capitalized. You can look at my example. Also, in case your first choice can't do it or won't do it for some reason, then you should appoint a backup executor. As a backup, you can appoint anyone else, but also bear in mind that you can appoint someone professional, like anyone from a specific law firm or someone you know who is a lawyer. Now we can talk about making your gifts. Making gifts is a simple and straightforward process. You just name your asset, like a car or a house, and then you say that you want to give this asset to a named person, or beneficiary as more commonly known. However, what can complicate the situation is the kind of gift you're making. You should consider, for example, whether the asset you're giving away has any encumbrances. So a house, for example, may still have a mortgage with a bank. In order to settle any debts you have, it would be advisable for you to instruct your executor to clear these debts using anything available in your assets. For example, a life insurance premium or any liquid cash you might have in your bank accounts. In this way, you can directly ask your executor to clear any mortgages to your house before it is passed to the beneficiary. Bear in mind that the beneficiary you have named might not be able to receive the gifts you have given them in the will. This may be due to the fact that they have predeceased you, or that they should even renounce your gift. In such an event, it's always advisable to name an alternate beneficiary to take the gift. Like appointing your executor, you should include the full names and details of your assets and the details of your beneficiaries and write them all in capital letters. Avoid any vague statements and be decisive in your language. You can follow the examples I've written down here. A common arrangement done in many cases is to name the spouse as the main beneficiary and then the children as alternate beneficiaries. In the case that both parents should meet their demise together, in this scenario, the will automatically reverts to gifting the estate of the deceased to the children. I must reiterate that you should also use decisive language. Don't make vague statements, as any uncertainties may lead to dispute about your intention. Remember, when people read this document, there is a presumption that you are already dead and cannot explain what you have written down. If you want to make more than just simple gifts and want to make conditional gifts, for example, it might be better to speak to a professional, like a lawyer, who can draft more complicated arrangements in the will. Let's briefly talk about children. Children are not yet adults, which means they will need guardians. In a normal situation, surviving parents of children automatically become guardians to their children. If you want to give your house to a child, then it will have to be held on trust, because children cannot legally hold property. The gift you make is valid, but it will have to be held on trust, so only when the beneficiary reaches the age of majority and becomes an adult, then can they fully receive the gift. In any case, if you want to give a piece of land to your own little nephew or your own children, you should know that there's nothing wrong with doing this. But at the same time, your nephew or children will have to wait until they have grown up before they can legally hold this property. During that time, the property will be held either by their parents or appointed guardians. Now that we've discussed about children, we should also discuss about guardians. Guardians can be appointed in your will. You can appoint them the same way that you appoint an executor. Remember that surviving parents are automatically the default guardians of children. However, if you, for whatever reason, should want to appoint someone else to be guardian, you can do so. This is a good decision in any case, because in the worst case scenario, your children might not be left with any surviving parents. By default, an appointed guardian must work together with other guardians. So if you appoint a guardian, they will have to cooperate with the surviving parent of your children. An appointed guardian can also challenge the surviving parent for custody of your children. It might be even in your interest to direct your guardian to challenge the surviving parent for custody of your children. This may be the case if you believe the surviving parent is not suitable for taking care of your children. Whatever you decide to do, know that it will have significant consequences for your children. So we will always advise that you seek professional advice regarding this matter. Now we can write the residue clause. The residue refers to the leftovers of your estate. This includes anything that you didn't mention or anything that failed as a gift. So for example, if a beneficiary decides to renounce their portion and there's no one left to claim the gift, then it will fall into the residuary as well. If you bought a new house or cars, or if you won the lottery and you did not have time to write a new will, all your new winnings and assets will then fall into the residuary. You can follow my example here. Everything that we talked about has now been compiled into one structure. So in the beginning here, I have included the intro. After that, the revocation clause. Then I appointed my executor. And then finally, the gifts and the residue. Now we can proceed with the execution of the will, where you can finally sign and turn this document into an official legal document, which is your will. Let's briefly discuss the witnesses of a will before we move to the execution. The law requires 2 witnesses to witness you when you sign your will. This means that you will need 2 people to watch you sign your will, and at the same time, they must also immediately sign the will after you have signed. There are rules that you should understand before selecting your witness. Witnesses should not be beneficiaries, otherwise the gift they're supposed to receive will become void. This will also apply to spouses of beneficiaries. If the spouse of a beneficiary becomes a witness to your will, all the gifts to that beneficiary will also become void. In general, it would be better to appoint someone outside of your will to become witness. This person can be a doctor at your hospital or your next door neighbor. If you appoint a professional, like a lawyer, to witness your will, it might cost more, but a lawyer will hold more weight as a witness and can guide you through the process more carefully. During the time of obtaining probate from the court, it would also be much more convenient if your witnesses can be made available. So it's probably good to have someone who is not from outside of your country and is hard to reach. It would also be convenient to have them write down their details next to their signatures. As you can see here, I've made a sample signing page. At the very top, I have my name and IC, and I have placed a dotted line where I can sign my name, including a space for my 2 witnesses and their details. And of course, very crucial to the execution is the signing date. We have now reached the end of the presentation. A few notes before we conclude. Remember that this is a general video guide for writing a will, so there may be things which I did not mention, and you can feel free to comment in the comment section below if you want to add anything. Also take note of your jurisdiction. The advice given here should be considered as general and might not apply to your specific situation. Pay attention to the rules in your own country and jurisdiction. Finally, thanks for watching. If you enjoyed the video or found it helpful, please like, share, and subscribe. Thanks for watching.